I'm gonna live react to this one because I've absolutely had to deal with this. I've absolutely had to deal with this.
This is a huge proposal and would have a big impact both on the amount of money that people make and really society at large.
The FTC is on the verge of increasing your paycheck as they are now looking to ban non-compete agreements, which studies show have historically held down wages. And this includes even for lower income jobs. So not just corporate jobs that typically have these non-compete agreements. So this proposal.
This is even sad, like for that there would even be non-competes out there for lower income jobs. That's really sad. But this is a very abusive form of agreement that employers use against their employees. I have so many thoughts on this. Oh my gosh, let's see what he says.
Proposal covers not just employers, but also or employees, but also independent contractors, interns, volunteers, and other workers as well. So I'm going to get to some of the details here. I'm going to show you a clip of the FTC on CNBC.
I hope, at some point they also take a harder look at non-disclosure agreements, because many of those non-disclosure agreements are not intended to protect proprietary information for the company. They are intended to make it so that you can't describe your workplace situation and like actually talk about the abuses that you suffer on the job. Because really the purpose of non-disclosure agreements really should be about protecting the data of the company, like protecting their proprietary information, protecting their client data. All of it should be really focused around that. And employers do abuse that form of contracting as well to try and silence employees if they have any grievances.
And she has to deal with a lot of pro-business arguments from the business network CNBC, so I'll show you how she tackles those. But first here, this is from the New York Times. The proposed rule would ban provisions of labor contracts known as non-compete agreements, which prevent workers from leaving for a competitor or starting a competing business for months or years after their employment, often within a certain geographic area. The agreements have applied to workers as varied as sandwich makers, hairstylists, doctors, and software engineers. Studies show that non-competes, which appear to directly affect roughly 20% to 45% of U.S.
Oh, it can go even deeper than that. There's also like, if you happen to be doing something in your spare time, like you come up with something, they can try and take ownership of your intellectual property if you're an employee of that company at the time that you come up with something. They are so bad. They're so bad. But yeah, I mean, like once you get skilled in a particular area, you should have the ability to move around or create your own business. That is non-compete is exactly what he's saying. It is an anti-competition situation, right? Which does lead to monopolies. That was the thing that was missed out of the other video that I covered, is the Sam Cedar one, the big data, is that in order for it to be a monopoly situation, it means that you do not have competition, right? So, for example, she said there was only two massive big data companies, which is patently false. It's just absolutely not true. But if they had non-competes in place, right, there's only, I mean, under her assertion, it's only preventing the workers from applying at the one other competitor. But the reality is it would actually prevent them from applying to several companies that do that sort of data curation.
workers in the private sector hold down pay because job switching is one of the more reliable ways of securing a raise.
Right.
Many economists believe they help explain why pay for middle-income workers has stagnated in recent decades.
Yeah, absolutely. My recommended advice to all of the young people in my life is, if you can, try and job hop every 2 years, because that's the only way you're going to get a sizable raise. Because the most they'll give you on the job is like 2% as a merit increase. They're not going to give you shit unless you get a substantial promotion or you job hop.
So if you can, imagine you're in a non-compete. You no longer, in that scenario, have the ability to use the argument that, hey, I'm being offered this job elsewhere for more money. Do you want to raise my pay here, or am I going to leave and take that job? In which case, depending how much they like you and want to keep you on, because it costs, oftentimes more to train someone new, they'll then, match that to keep you. But if you have a non-compete, you can't do that. You lose that leverage over your employer. So here they're simply trying to bring it back to a situation where not only is it better for the employee, but it also increases competition, allowing new companies to come in and hire within that industry, because non-competes in this scenario would no longer exist. So, and I've showed you, it's not just, non-competes, of course, aren't the only problem. Far from it when it comes to how much power employers have over their workers. Of course, union membership rate, I've shared this a million times now. If you watch my videos for any time, or for sometime, you likely have seen this graph. But from the EPI here, union membership rate and share of income going to the middle 60% of families, 1917 to 2013. So you see here, as union membership rate declines, so does the share of the overall income going to the middle 60%.
Let me tell you how this works in practice too, because I know a lot of these live streamers probably have never actually faced these actual scenarios, right? And so while they cover it, and they probably have researchers who are prepping them and giving them the information of, this is the message that you need to communicate, right? When I was working for the Unite Here PAC in Georgia, and I was walking blocks to help flip the Senate back in 2020 and the first week of 2021, right? I was also, in my spare time, interviewing for a proposal job, trying to get back into the industry. And the offer they gave me, because they did make me an offer, but they didn't give me all the details until I had already arranged my flight home a couple days before our Canvas operation was actually going to end. So I actually lost a few days of pay as a result of this. The offer they gave me is that I was going to be temp to hire. And like I said, this is a big problem, especially going into a recession, is that these employers are going to be using contract labor to get around permanent employment laws. So I was offered temp to hire, and they wanted me to sign a non-compete. So they were unwilling to make a commitment to me to keep me on staff, but they wanted to prevent me from working in any other similar industry to their industry for a year. And that's some bullshit. That's some bullshit. But I'm so glad to see that that's getting out. Like, we're not going to have this problem anymore. That's good. We still have the problem with contract employment though. But that's not what the Federal Trade Commission does, the FTC, right? That they are more concerned about competition. And that's why they're able to get into this particular area.
And that isn't just people in unions. We're talking about all workers, because of the power that unions have over industries to essentially raise the standards for what is acceptable in the workplace. So that is still, the biggest issue here when it comes to the voice of workers. But getting rid of non-competes would definitely move the needle. So Before I get to the clip here, a little more. Other studies show that non-competes protect established companies from startups, reducing competition within industries. The arrangements may also harm productivity by making it hard for companies to hire workers who best fit their needs. The FTC proposal is the latest in a series of aggressive and sometimes unorthodox moves to rein in the power of large companies under the agency's chair, Lena Khan. So I'm going to get to commenting on a couple other, or at least one other angle or one other lawsuit that the FTC is engaged in, and my thoughts on that, because I actually disagree with one of the things the FTC is doing, even though largely they have done a fantastic job here under Joe Biden. But let me show you first here some comments from Lena Khan on, of course, as I said, CNBC, the business network, but this is the place to go to make the argument. So she's here making that argument. Here's a bit of this clip.
So non-compete clauses today govern around 1 in 5 U.S. workers. These clauses may have started in the boardroom, but today what we see is that they've proliferated across sectors and across income levels. So we're talking about nurses, we're talking about fast food workers, janitors, but also physicians and engineers. And we've now seen that
That's so crazy. That is so crazy that, like, the entry-level sort of work would even be bound by non-competes. That is so crazy to me. I mean, that's usually a document that's reserved for people who have intelligence about the company. You know, you've got insight into the actual client data, or you have insight into the proprietary services that, like algorithms or things that they are doing that they don't disclose because it's considered confidential and proprietary as company, as like their protected company information. And maybe that's what that gal was referring back to on the Sam Cedar video about the 10,000 sources, that they're not disclosing the 10,000 sources. I think in a government, if they have government contracts, they still would have to disclose their sources in a FOIA request. But they could try and argue that it's confidential and proprietary. But I digress. Point being is that what the hell do you need to have a non-compete in place for a nurse or a janitor? Why? What are they doing that could potentially put your company at risk if they go to another company? Like that's so fucking stupid.
Aggregate, these clauses can really restrict competition, both in labor markets, but also in product markets. And so our economists calculated that collectively American workers are earning around $300 billion less because of these non-competes, and that on the whole, innovation and entrepreneurship are suffering.
Now there's some.
I'm glad.
So I'm going to get to a little more here. So that's the overall view around, 300 billion in wages lost per year because of these non-competes alone. But here is where Lena Khan fields a lot of these questions from the pro-business angle. So of course, 4 minutes of this, but it's worth watching.
What do you say to some?
How she responds to all of it, because she has a great response to all of it and does a good job here at shutting down all of these.
Well, and the other thing too is like, okay, so when I was presented with that ridiculous offer and I had lost a couple of days of work because I thought I was going to be signing contracts that made sense. And when I read through it, I was like, what the fuck is in here? Right? So they actually got me to like cut a job short. I lost late income as a result of them telling me they were going to hire me and then doing a bait and switch. I mean, yeah, I lost a lot of income over that. And so I can see how this, and I was in this was going to be a professional upper income job. And on top of it, they also said that while I was in the temporary portion of the temp to hire, that they were going to pay me a certain amount that was pretty close to 6 figures. It was pretty close to what I was formerly making. But then when I went permanent, they were going to reduce my income by $20,000 because they were giving me a $20,000 bump to pay for my own healthcare, my own benefits and stuff, right? And I'm like, I'm worth more than this. I was making more than this. And you're putting such incredible restrictions on my ability to actually perform for you, and you're making no commitment to me. Employers, do better. It's a partnership. We're not just fucking cattle. We're not just warm bodies. We are your talent. Treat us better.
Pro-business positions.
Somebody the critique of this would just say, okay, there's a free market, and the employer effectively is paying for the privilege. They are paying you effectively for the non-compete.
So
meaning people can agree to contracts, and one of the contractual terms may.
What did I just say? That's the thing. They're like, I've bumped your income up so that I'm covering the cost of whatever losses you have for not getting benefits and for being in a non-compete. That's some bullshit. Oh my God, even. Pay us what we're worth and don't try and put these ridiculous restrictions on us.
Very well be, I'm going to pay you a little bit extra, or whatever you think is appropriate, so that you don't go off and work for my competitor tomorrow.
Yeah, in theory, I think we've seen that people suggest there is that premium. I think we don't always see that in practice. Sometimes employers are actually imposing these on workers even after they've agreed to a job.
On that point, I'll get back to this, just to share this. One study found that only 10% of workers sought to bargain for concessions in return for signing a non-compete. About 1/3 became aware of the non-compete only after accepting a job offer.
Yep.
The idea that these employers are really proactively raising wages because they have included non-competes is ridiculous. Only after you have maybe asked for higher pay because you see a non-compete.
Oh, and on top of it, a lot of these employers will also do a bait and switch on mediation agreements. So you'll already have the job, you're on staff, and they'll change up their employee codes, the employee handbook, and throw in a mediation clause that maybe wasn't there before. And then they ask you to sign that you have received and read the employee handbook. Now, in California, they're required by law to let you opt out of the mediation clause. But most employers do not give you a place where you can opt out. And if you're difficult about their employee handbook, then they know that you're a problem employee now.
Only then maybe they will decide to raise that pay if they have no one else for that position that they can put in that spot that would work just as well as you would. So, yeah, there is no situation where an employer is going to raise your pay just because they have included that. Why would they unless they are forced to? This is how all employers operate. They're going to try to hire you for as little as they possibly can.
Right.
That way, they make a larger profit.
I think what we've also seen is that on net, this can be bad for competition in ways that we should be concerned about regardless. At the FTC, sometimes we hear from founders who were able to secure capital, they were looking to enter a market, they were able to build the factory, but at the end of the day, they weren't able to build and scale because all the relevant workers, the talent, was locked up. And I think when you look at states like California, that for decades have rendered non-competes non-enforceable, I think you can see that there can be a huge boon to innovation and competition.
What about the idea of trade secrets? So part of this, and a lot of this comes from tech, where people have a view that there are folks who are engineers or others or in healthcare who have trade secrets. They know stuff. And so you don't want them to be able to go across the street and take either the trade secrets.
That's a non-disclosure agreement. Okay? They can still go across the street with everything that's in their head. But there are specific data points that they cannot share. I've gone through this several times. You cannot share the client information. You can't share the internal proprietary and confidential information about how the business runs. But for any sort of processes or whatever, if you learn something while you're on the job that you can apply in another capacity, that's not the same thing. That's not the same thing.
Themselves, or even sort of adjacent knowledge, if you will, in the immediate term at least, right? It's not necessarily just the trade secret unto itself. It's, you know what, even if they don't tell the other employer exactly what the other guys, they know too much, and that has value, at least in the first 6 months to a year out from that job. So we want to hold you away from having that happen for some period of time or what have you.
Look, it's a reasonable concern. And at this stage, what we've seen is that there are alternative tools to non-competes that you can use to protect legitimate trade secrets, legitimate IP. So you can use non-disclosure agreements that can be tailored. We also have trade secrets law, right? Employers bring hundreds of lawsuits a year to enforce trade secrets.
The conundrum there is that's after the fact. It's typically, when I say after the fact, it's typically after somebody has arguably taken a trade secret and...
No, you sign a non-disclosure agreement with your employee records as well. That it depends on your role in the company probably, but like it's usually a part of your hiring package. So you're just making up bullshit right now. The appropriate way to protect data of a company is a non-disclosure agreement, not a non-compete.
Used it, and so the employer has...
I just gotta look at how proactive this network is when it comes to defending the profits of massive corporations. This is like, you will never see them try and make this argument on the other side, where people are getting screwed. Their wages are lower for a variety of reasons, one of them being non-competes. But when it comes to like, oh, because the employer, the company has to sue them after the fact, go after them after they discover this issue, they should be allowed to prevent them from even having another job at all. That's the solution. It's just like, I understand his position here is to push back and ask these questions. That's his job. But this is their only perspective. They never have the other perspective of the worker.
Has been quote unquote injured, right?
Which, by the way, last point on this, I've said this before. CNBC is a business network. There is no equal of that on the employer side. There is no union network from NBC. So there's NBC, which is already pro-corporate. Then there's CNBC, which is tailor-made for large corporations. There is no labor NBC. Just to give you, again, the which is, yes, obvious because we're talking about capitalism. This is how they operate. But it just to show you how they are not unbiased here. They have a perspective that they showcase, yet they are unwilling to really own that their perspective is always going to be pro-business. They pretend they are neutral when in fact they're only giving you one perspective on these issues. All right, let's finish this off.
They're having to show injury. One of the reasons they have non-competes or these type of arrangements is to prevent even getting into a position where they have to show injury first, right?
That's right. Though we've also seen instances in which people break non-competes, they go anyway, and
right.
Employers are having to enforce after them.
Well, that's kind of like the bullshit that it's kind of like the bullshit that Sam Cedar was trying to pass off of police using publicly available information to supposedly arrest people before they even commit a crime. They don't usually do these non-competes at the C level. I'll be real with you. They're not doing it at that level because at the C level, and who have the most information, by the way, they would never accept a scenario in which they can't leave the company and go to a better offer. They would never accept that. They would never accept that because they know that they have a specialized skill of running large organizations and they have more information than anybody else in the company, and those non-competes are not going to be thrown at CEOs. That they're not, because they have a specialized skill, and they would not accept that because they know that they want to be able to go to other companies, and in fact, a lot of them cycle out for that specific reason. Like, you've got specific skill types among CEOs. Some CEOs are specifically target growth of a company and innovation. Other CEOs are brought in to specifically downsize corporations. So they have a specific skill too. But those guys and gals have more information than anybody else in the company. They have access to absolutely everything. There is no way any CEO would be cool with a non-compete when they are constantly job hopping for that reason, because of their specific talents of whether they're a downsized CEO or they are a growth CEO.
Fact anyway. But at this stage, our thesis is that there are these alternative mechanisms that would still protect legitimate trade secrets, protect IP, but not have such a drag on the economy in the way that we see non-competes do.
What do you say to those who say, look, the FTC actually doesn't even have the authority to put this rule into place? It's Section 5, and we can get into details of what that is, doesn't really allow for this. And if it ever got to the Supreme Court, especially given the politics of how you think about the Supreme Court today, that this is dead in the water before it starts?
Look, Congress gave the FTC the authority to check unfair methods of competition. They told us that we could do that through a variety of ways, through bringing lawsuits, but also through bringing rules, through issuing market-wide rules. And so we're confident that the text and structure of the FTC Act gives us clear authority to do this.
So it's very likely that there will be lawsuits over this, because anytime you're going to potentially decrease the profits at all of a business, of an industry, because of pro-worker measures, there's going to be a challenge, because all the money, all the ability to challenge these kinds of things are on the side of the employers. So they likely will try and challenge it, and they may be successful. But it is definitely, it appears to be, within their authority here to do these kinds of pro-competition measures, which, again, yes, this also helps competition, along with helping employees.
There have been times where you have proposed rules, they've had a comment period, and then you have not enacted those rules. How do you think about that?
Yeah, it's a great question. So as you noted, this is a proposed rule. We've put out a proposal. We're going to be collecting comments for 60 days. The proposed rule is based on our survey of the available evidence, but we also include a set of questions that we're inviting the public to comment on. So once people have finished commenting, we're going to look at that full record and determine what's the best way to go forward. So we really encourage people, be it employers, be it startups, entrepreneurs, workers, to submit comments and help us decide how to proceed.
All right, so we will see if this goes through. Again, there's, as she discussed there's going to be a waiting period with questions that'll be submitted. Last thing I want to comment on here. So, New York Times writes, Ms. Khan has brought lawsuits in recent months to block Meta, Facebook's parent company, from buying a virtual reality startup, and Microsoft from buying the video game publisher Activision Blizzard. Both cases employ less common legal arguments that are likely to face heavy scrutiny from courts, but Ms. Khan has indicated she is willing to lose cases if the agency ends up taking more risks. So I actually like this approach, even though I will say here, I do not think their lawsuit against Microsoft in their pursuit of buying Activision Blizzard, I don't think this will be successful. It would take a whole other video for me to really, get into it. But essentially, this is not the claims being made by Sony, and I own all the consoles. I'm a big gamer.
Well, the thing too is like, Activision Blizzard has so many culture issues right now, and Microsoft has in the past too. Different types. They've had their issues with using contract employment, and they had a massive class action suit against them for co-employment because they were bringing in contract employment that was there for over a year. And if you have somebody on a contract employment situation for over a year, the court has ruled that you are the permanent employer. Like, you can't keep getting around employment law if you're going to have them on board for that long. So that's Microsoft's problem. Activision Blizzard, on the other hand, has a huge problem with misogyny and sexual harassment. So it's possible that Microsoft might be able to clean that up a little bit, but I don't know. I really don't know. But Blizzard's right up the street for me, y'all. Largest employer in Orange County.
The claims being made by Sony are not accurate in terms of the power that Call of Duty under Activision Blizzard has over the entire industry. Nintendo is currently the most successful video game company in terms of consoles sold with the Switch. Mm-hmm. They don't even have Call of Duty on the platform. So you can't have Sony claiming that Call of Duty makes or breaks companies when Nintendo doesn't even have Call of Duty on the platform, and they are by far in first place. But still, I'm still glad that they brought the lawsuit forward, because it shows you they are being more proactive, more willing to challenge these sorts of attempts to, just consolidate industries. So it's good to see, and it's even better to see this rule potentially get implemented here, this bar on non-compete agreements. Let's hope they are successful, because there is very little power right now that employees have. So to have this extra bit of leverage over their employer would only be a great thing.
Yes, it would. Yep.